You are sitting in the back of a police car. Your hands are cuffed. The door slams. And no one has said a single word to you about your rights. You have seen it 100 times on television. The officer pins someone to the hood of a car and recites those familiar words. You have the right to remain silent. Anything you say can and will be used against you in a court of law. It is practically a cultural ritual at this point. The Miranda warning. 5 lines that every American believes are the wall standing between them and a wrongful conviction. But here is what almost no one knows. If the police arrest you and never read you those rights, nothing automatically happens. The charges do not disappear. You do not walk free. The handcuffs do not fall off. In most situations, the arrest is completely valid. So what does the Miranda warning actually do? And what happens to you when it is skipped? The answer is more complicated, more surprising, and frankly more unsettling than anything you have seen in a courtroom drama. And it starts with a single interrogation room in Phoenix, Arizona, in the spring of 1963. His name was Ernesto Miranda. He was 23 years old and he had been arrested on suspicion of kidnapping and sexual assault. Phoenix police detectives brought him into a small room, sat across from him, and over the next 2 hours, questioned him without once telling him he had the right to stay silent. Or the right to have a lawyer present. Miranda signed a written confession. That confession was used to convict him. His attorneys appealed. The case went all the way to the United States Supreme Court. In 1966, Chief Justice Earl Warren delivered the majority opinion in Miranda v. Arizona, ruling that any statement made by a suspect during a custodial interrogation, meaning questioning by police while you are not free to leave, could only be used in court if police had first informed the suspect of specific constitutional rights. The right to remain silent. The right to have an attorney. The warning that anything said could be used against them. That ruling created what we now call the Miranda warning. But here is the thing the Supreme Court did not say. They did not say police must read you your rights the moment they arrest you. They said police must read you your rights before they interrogate you if they want to use your statements in court. That distinction is everything. You can be arrested, handcuffed, searched, booked, fingerprinted, and put in a holding cell, all without a single Miranda warning. The arrest itself is not affected. What the Miranda warning governs is the admissibility of your statements in court. It is a rule about evidence, not a rule about the arrest itself. Legal scholar and professor at Yale Law School Akhil Reed Amar has written extensively about this distinction and the widespread public confusion surrounding it. The belief that an un-Mirandized arrest is automatically invalid, he argues, is one of the most persistent and consequential legal myths in American culture. Television created it. Decades of procedural dramas reinforced it. And it has left millions of Americans dangerously unprepared for what actually happens when they are in police custody. So what does actually happen? If police arrest you and begin questioning you without reading you your rights, anything you say during that interrogation can be suppressed. Suppressed means a judge can rule it inadmissible. It cannot be shown to the jury, it cannot be quoted in court, it essentially never happened in the eyes of the legal proceedings. Your lawyer files what is called a motion to suppress, arguing that your statements were obtained in violation of your Fifth Amendment rights, which protect you from being compelled to be a witness against yourself. If the judge agrees, those statements are thrown out. But here is where it gets complicated. Throwing out your statements does not throw out the case. If the prosecution has other evidence, physical evidence, witness testimony, surveillance footage, cell phone records, none of that is affected by the Miranda violation. The case continues. You can still be convicted. The suppression of your statements is meaningful, sometimes critically meaningful, but it is not a get-out-of-jail card. Now consider the opposite scenario. Police arrest you, read you your rights clearly and correctly, you understand them, and then you start talking anyway. You are nervous. You think you can explain your way out of it. You answer every question. You fill in details the police did not even have. This scenario, where a properly warned suspect voluntarily speaks, produces far more convictions than any Miranda violation ever prevented. Research by criminologist Richard Leo, whose work at the University of San Francisco includes a landmark study of nearly 200 custodial interrogations, found that roughly 78% of suspects who were properly Mirandized chose to waive their rights and speak to police anyway. 78%. After being explicitly told they could stay silent. After being explicitly told anything they said could be used against them in court. They talked. Why? Because silence feels like guilt. Because explaining yourself feels like the right instinct. Because sitting across from an authority figure who seems to already know things about you triggers a deep human impulse to justify, to clarify, to connect. And trained interrogators know this. The Miranda warning, delivered correctly, is often followed immediately by techniques specifically designed to reduce your resistance to talking, building rapport, minimizing the apparent seriousness of the offense, suggesting that cooperation is your best path forward. Let us reconstruct a scenario. You are pulled over late at night. The officer asks you to step out of the vehicle. A second officer arrives. You are told you are being detained for questioning in connection with a robbery that happened nearby. You are not free to go. One officer guides you to the back of the patrol car while the other searches your vehicle. No Miranda warning is given. No one explains your rights. An officer leans in. He tells you they already have you on camera in the area. He says this will go a lot easier if you just tell him where you were and what you were doing. He seems relaxed. Reasonable. He is not yelling. This does not feel like what you imagined an interrogation would feel like. And so you start explaining. Everything you say in that patrol car, if no Miranda warning was given before that questioning began, could be challenged later. Your attorney could move to suppress it. But whether that motion succeeds depends on a judge's analysis of whether you were truly in custody, whether questioning was truly taking place, and whether the circumstances created the compulsion the Supreme Court was concerned about in 1966. The legal definition of custody is not simply being inside a police car. Courts use a test based on what a reasonable person in your exact situation would have believed, whether they would have felt free to end the encounter and leave. This standard means the suppression of your statements is not guaranteed even if no Miranda warning was given. The outcome is evaluated case by case. And there is a further wrinkle. In 2010, the Supreme Court ruled in Berghus v. Tompkins that simply remaining silent is not enough to invoke your Miranda rights. You must affirmatively invoke them. You must say, out loud, the words, "I am invoking my right to remain silent." Or, "I want an attorney." Until you do, police can continue questioning you, and anything you say during that continued questioning can potentially be used against you, even if you have been silent for 2 hours beforehand. Justice Sonia Sotomayor wrote a strong dissent in that case, arguing that the majority ruling turned the Miranda warnings protections inside out. Where Miranda had required a knowing and voluntary waiver of rights before police could use a suspect's statements, Berghus effectively allowed silence to function as a waiver. But the majority opinion stands as law. What this means for you, right now, is this. The Miranda warning is real. The protections it offers are real. But they are narrower, more conditional, and more dependent on your own actions than almost anyone realizes. The most protective thing you can do if you are ever in police custody is also the simplest thing and also the hardest thing. You say nothing. You ask for an attorney. You repeat those 2 requests calmly and clearly every time you are asked a question. You do not explain. You do not clarify. You do not justify. You wait for legal representation. Not because you are guilty, but because the rules of the room you are in were not designed to help you. They were designed to produce a confession. And even the warning that is supposed to protect you has been shaped, over decades of court rulings, into something far less powerful than the 5 lines on a television drama. Ernesto Miranda, by the way, was retried after his confession was thrown out. The prosecution used other evidence. He was convicted again. He served 11 years in prison. After his release, he was stabbed to death in a bar fight in Phoenix in 1976. The man suspected of killing him was taken in for questioning. He was read his Miranda rights. He invoked them. He was never charged. The warning did not save Ernesto Miranda. But on the night he died, it may have saved someone else. The next time you hear those 5 lines read on a screen, you will know what they actually mean. Not a magic formula. Not an automatic escape. Just a narrow legal rule about what words can follow you into a courtroom. What follows you in is still up to you. You are still sitting in the back of that police car. No one has said a word to you about your rights. Now you know exactly what to do.